Ready to go? Okay, folks, welcome everybody. I'm looking for cues from our AGP folks. Thank you. We're ready to go. Okay, so I'll open up the meeting. Welcome everyone. This is a special City Council meeting workshop. Today is Wednesday, the 1st March 2017. Pardon me. We're located at the Community Center here in Moore Bay. Our meeting is starting at 4 p.m. The special meeting will be discussing Proposition 64 and marijuana law, and so this is a workshop for that. For the record, all members of council are present. We do have a quorum. We'll call the meeting to order, and then we'll get into the workshop format. So that was kind of the formality of calling the meeting to order and getting on with that. We'll turn it over to our city manager, Mr. Buckingham, to lay out the framework of this, and then our city attorney, Chris Newmeyer. So we'll start with that.
Great.
Okay?
Thank you, Mr.
Thank
Mayor. First, let's introduce Chris Newmeyer, who is one of our assistant city attorneys, and he is an expert in this area of the law, and thus is spending some time with us this weekend. So glad he's here. So the purpose of this session is really education. It is an opportunity for the council to dig more deeply into what the law was and what the law is now, and based on the changes in the law, what options there are for the council. And options might not be the best word. There are some things that perhaps the city, as Chris will go through, it's essential that the city do something about. And then there's other things that the city can choose to do one of several things or nothing. But the key purpose is not to make any decisions tonight. That's not what we're about. We're about educating ourselves, educating the public, and then the one bit of a direction that we will probably look for near the end is, based on the discussion that you had tonight, 2 weeks ago, where do you see the next steps going, and what we sort of anticipate will be a 6 to 12 month process of determining where Morro Bay wants to go in these various areas. I'll note that the tables are set up to hopefully facilitate that discussion format. You can leave your microphones on so we can have a back and forth and discussion and say, hey, what about this? Or did you think about that? Or can I get this point in? If you need to cough or something, you could turn it off then. But Bob over there is going to try to keep the noise, the audible levels, so that we can have a discussion and it feels a little bit less like I have to grab the mic and make a comment, and feel free to have a great discussion. And with that, Mr. Mayor, I'll turn it back to you for, I think, public comment.
Yeah.
I'm sorry, I should have noted as we go through the agenda, Chris, if you'd advance one so you can see the agenda. Chris is not going to present 30 slides and then discuss. He's really going to do number 1 and number 2. And then open it up for discussion on those items, just like we did last night with the budget. And then he'll present 4 slides on personal cultivation, and then stop there and have a discussion on that, so that the council really can focus in on these discrete areas: personal cultivation, personal use, commercial operations, and taxation and fees. Okay, thanks.
So great. So we'll start with public comment. Fairly informal, and then we'll go through this. We are putting a time limit to our meeting, and we're expecting to conclude about 5:45, and so we get out of here at 6. But that doesn't mean we're going to be short-sighting any information, because this is, as Dave was saying, this is a continuing process, and we're going to keep building on this. So with that, I'll open up public comment, and hopefully at the end we can conclude with public comment as well. So welcome. For those that'd like to make public comment, please come to the mic, and we'll start with that. Please state your name for us. Please state your name for us, and then we'll get going. Thank you.
I wasn't sure this is high enough. My name is Rick Morris. I operate Mid-Meyer Clinic in Fresno, California. Up until January 29th of 2016, we were an open dispensary. We've converted to a referral service and a consultation service because there's a lot more important work in getting the right medication to the right people. But I do believe in the medical aspect of marijuana. As a member of the priesthood, I don't promote or support the recreational. Although, truth be told, I voted for it. So it's one of those things. I appreciate you guys having this. I didn't think all you guys would be here, but thank you for taking the time out of your schedules to be here and to openly discuss this. Thank you very much.
Thanks, Rick. Anybody else for public comment?
Hi there, my name is Steve Babcock. I'm Operations Manager for Los Osos Collective Organics. We're a local delivery service. We deliver mainly medical marijuana. I'm really concerned about some of the things that you guys have on your agenda here. One of them was possibly not allowing deliveries to come into Morro Bay. What I'm for is safe access for medical patients. We do a lot of pain relief topicals, balms, things that are more non-psychotropic, a lot of CBD type of things for patients that have stage 4 cancers, lung cancers, a lot of different issues with multiple sclerosis and things like that. So we're very into the healthcare benefits of marijuana. Again, we just want you guys to understand that we want safe access for our patients. We do have patients here in Morro Bay, and we would love to have you guys open up a discussion about allowing the deliveries to come in, also brick and mortar dispensaries in Morro Bay to allow safe access for patients that need it. Thank you very much. I hope you guys have a great discussion about this, and thank the city very much for opening up the discussion right now, starting this process early in the stages. We really appreciate that.
Thanks, Steve.
Hello, my name is Eric Powers. I'm the CEO of Megan's Organic Market. We're a organic cannabis cultivator and delivery service. We've been operating in the Morro Bay, Estero Bay area for over 3 years now. I just wanted to come today so I could help answer any questions anyone might have about our industry, about our cultivation practices, about what a typical patient for us looks like. There really isn't a street in Morro Bay where we don't have a patient on. This is something that's prevalent throughout the community. It's an important part of the community. We really believe in it, and I hope I can help.
Thanks, Eric. Anybody else for public comment? Welcome.
Thank you. Hi, I'm Adam Pinteritz. I'm the Community and Government Relations Director for Ethnobotanica, a organic cultivating vertically integrated medical collective on the Central Coast with patients all across San Luis Obispo County. I wanted to first offer an additional information binder to the city and council and staff. I provided one to you about a month ago. I've since added a significant amount of information to it, so for your benefit. And I want to be respectful of everybody's time here, so I will remain for the duration of the meeting to answer questions, but I also wanted to give two of our drivers the opportunity to introduce themselves before they need to go and continue serving patients here in the area.
Thank you. There you go, perfect.
Good afternoon. I'm Rich Besko. I'm one of the delivery drivers for Ethnobotanica. I've been doing this about 7 years in this county. I think I'm about as good a resource as you'll find for medical cannabis in the area, and one of the things I really take pleasure and pride in is helping the medical patients. When I started this job, I wasn't sure how much would be medical and how much may be recreational oriented. I got to say that the medical has been very rewarding for me, and I think everyone wants to see that continue. A lot of people have questions about the recreational. I do support recreational use, and I think it's a lot less scary than it needs to be. People have a lot of apprehension about it, I know. I would just make it real short and sweet. Take a look at what we do with alcohol in this county. How much is going on downtown San Luis Obispo, a lot of places. The impact to the public safety and public health from that is insignificant compared to what a recreational use would be, in my opinion. It's not to say we want to be a free-for-all. I'm all for local control. I think reasonable city regulations to limit, where you can use it, how you can access it, I think that's all good. But as we move forward, I just hope everyone will have an open mind and consider all the options, because I think there's a lot of misinformation and a lot of fear based around cannabis, and there really doesn't need to be. I've been doing this 7 years. We've never had a crime problem. I think that can be handled. The money issue is a little concerning, but that's being worked on as well, because the federal government makes it a little harder to have, credit and banking services, but I think that's going to change soon. So I hope with everyone's help, we'll move forward in a positive way. Thank you.
Thank you. Thanks, Rich. Anybody else for public comment?
My name is Lindsay Shubin, and I've been working with Ethnobotanica for about a year. I fully support recreational cannabis, and I fully support medical cannabis. It has completely changed my life for the better. A few years ago, I was in an accident at work, and my workers' comp ran out, and I was still in tremendous amount of pain. I didn't have health insurance at the time, so I turned to cannabis to help mitigate the pain so I could still work and function. Since that initial trial run of cannabis, I have learned so much, and it has enabled me to function as a person, as to be a functional member of society. 2 years ago, I had an extreme problem with my PTSD, and I was unable to leave the house for really basic necessities. And this enabled me to go to my therapist, to talk about mental health, to make this a really important part of our community, because it's already there. It's not the recreational, but the medical's there. But you know, there's a need. I deal with a lot of end-of-life care, the palliative care, and it is some of the most satisfying work I've ever had the privilege of doing. Being able to ensure that the last days you get to spend with your mother, your father, your family member, whoever it is, even if it's a pet, it's really important to me, and it's really important to this company, and it changes lives. There's so many stories I could tell you about people who are able to function again. They're able to be themselves. They're able to go out and see their family and friends. And that's something that's really hard to do with traditional medicine. With cannabis, we've seen drops in opioid addiction and overdoses and things like that. And I see that as, you know, the first step to really getting that information out there and making it a good thing instead of something that's slightly stigmatized, because there doesn't need to be a stigma. Thank you.
Thank you.
Hi, my name is Rigmore. I'm probably the only one here that's never smoked it or tasted it or done anything with it. But if I ever needed it, this is what I would want to do. I have a son that had a rotator cuff damage, and he was in extreme pain. I don't have a doctor. He's never had a doctor. We didn't know what to do. I finally got him to go to Kaiser in San Francisco, and he got in, and of course he would probably need an operation, but the pain, and he didn't want to take, I think it was oxycodone. That's what the word I thought I heard. And he says, isn't there something else? And the doctor says, you could try medical marijuana. And he actually came down here, and he had a little pipe or something. I actually was caught by a cop driving too slow, and he saw the pipe there. I had to tell him it's not my pipe, but anyway. Anyway, I want my grandson to come today to tell what a difference it was, but he's too embarrassed because he's one of those that doesn't do drinking, smoking, marijuana, nothing. He just run to feed the poor and all that good stuff. So I have seen it. Well, and like I told yesterday, I've seen it with my girlfriend in Norway. I would definitely, if something happened to me and I needed something, I'd go right up to Dr. Heading and I say, could you prescribe me something because I want some medical marijuana. Thank you.
Thank you.
Good afternoon. I'm Megan of Megan's Organic Market, and we are organic commercial cannabis cultivators, and we also have a retail delivery service. We've been in operation for almost 4 years, and we have almost 2,000 San Luis Obispo residents that are our regular customers. Morro Bay, by far, we do more business in Morro Bay than in any other city. And let's see, we just are here to answer any questions you all might have about cultivation and retail, and to answer some of your guys' very legitimate concerns, such as water usage, pesticide runoff, housing shortages, and whatnot. Thank you.
Thanks. Okay, thanks. It'd be great if we could get going, because a lot of this is information for us. Go ahead. Yeah.
And actually, it's kind of appropriate as I'm wrapping up. I am actually the president and CEO of the newly formed
San Luis. State your name for the record,
Oh,
please?
I'm sorry. My name's Marie Roth. I always forget that part. Marie Roth, the new president and CEO of San Luis Obispo County Cannabis Business Association, and that is a trade organization, a 501c6, that we're going for, just to represent the cannabis industry and all of these folks that are doing business. Our goal is to help them become compliant, through the regulation and bring the policymakers and the industry together.
Okay.
So, thank you.
Thank you. All right, great. And with that, we can get back into our presentation and then start on all the information. Turn it over to Chris. You want to start going on that? Or
Hi,
Great.
good afternoon.
Thanks.
My name is Chris Newmeyer. I'm your assistant city attorney, and I also have a specialization in marijuana law. And I'll be doing a presentation today, working with City Council on going through some of the educational issues involved with the regulatory options that the City Council has now. And I also want to, just as a matter of background, let the council know, the members of the public, that I have for quite a few years now been wearing both hats when it comes to marijuana law. I have helped cities prosecute illegal dispensaries and cultivation sites. I've also helped cities throughout California set up permitting schemes and taxation and develop regulations for dispensaries, cultivation sites. So I just take my direction from the client, and I've worked with quite a few cities recently. The trend has been with regulation, permitting, and taxing. So if there's any questions during this presentation as I go through this PowerPoint, I encourage the council to ask as I'm talking, and we'll also have some breaks as I go through the topics for discussion. So the first slide that I wanted to talk about was action items moving forward. I would strongly encourage the City Council and the city to consider possible further action on 4 main topics. Now, there's been a lot in the news about, of course, the passage of Proposition 215, the Adult Use of Marijuana Act, Prop 64, and we also have in the past the Medical Marijuana Regulation and Safety Act. We have the Medical Marijuana Program Act, Compassionate Use Act. It can get very confusing. And so I wanted to boil it down to just 4 basic things that I would strongly encourage the city to consider. The first one is personal marijuana cultivation, both indoors and outdoors. And I'll talk about the details of that later. Personal marijuana use, what the city can or cannot do now after the passage of Prop 64. Commercial marijuana operations, which include both for medical and recreational, basically 5 different types, which is retail sales, dispensaries, cultivation, testing, manufacturing, and delivery, and then also the issue of taxation and fees. So these are 4 issues that I would suggest the city to strongly look into. There are 3 issues, though, however, that I definitely think I would recommend the city take some action on, because not taking action is a form of action as well. These are 3 issues of local control. The first one is the regulation of indoor personal marijuana cultivation. As I'll discuss shortly, right now, indoor cultivation of personal marijuana is legal. Prop 64 has legalized that. The city can regulate it, or the city can leave it unregulated, but that's a decision to make. Second, by January 1st, 2018, the city, I would suggest, should make a decision on whether or not it's going to allow commercial recreational marijuana operations in the city, and also whether or not it's going to allow commercial medical marijuana operations within the city. And that's because, again, there have been a lot of laws, both the people of California and Sacramento have recently passed, but bottom line, January 1st, 2018, the state of California will start issuing licenses to people for both medical and recreational marijuana businesses. And so cities need to be prepared. Are they going to ban those businesses? Are they going to allow some of them? Are they going to regulate them? The city should make choices on what they want to do there. And the third issue, in addition to indoor cultivation, the business operations, the third one is deliveries. The city will need to make a decision, and by not making a decision, they make one as well, on whether or not they want to allow deliveries starting in 2018 into the city. Starting in January 2018, the delivery of medical marijuana and recreational marijuana will arguably be legal unless a city prohibits it from outside of the city. So the city should address that issue before 2018. And to be clear, City Attorney's Office is not advocating one way or the other which way the city should go in any of these decisions. We're just laying out the decision points. So before we get into the four main issues that I'll talk about today, which is cultivation, personal, and whether we want to regulate that or not in the city, and then talk about personal use, commercial operations, and then taxation and fees, I want to just give a brief history of marijuana laws, both nationwide and within the state. And again, if any of the council members have questions as I go through this brief history, please interrupt me and I can elaborate. But very briefly, in 1970, federal government passed the Controlled Substances Act. It prohibited all marijuana nationwide, cultivation, use, possession, made it a controlled one substance, and it said that there could be no research on marijuana, that there was no medical use. It was completely banned. In 1996, California voters passed the Compassionate Use Act, Proposition 64. This was the first medical marijuana statewide law throughout the nation, and what it did was it decriminalized medical marijuana in California. 2003, California legislature passed the MMPA, Medical Marijuana Program Act. What this did was it attempted to bring some regulations to medical marijuana in California. From a local government perspective, it really didn't clarify much. A lot of local governments found problems with whether or not they could or could not regulate what were called cooperatives and collectives. There were a lot of court cases on local regulation. And this eventually led to the recent passage of the Medical Marijuana Regulation and Safety Act, which I'll get to. But after 2003, in 2013, interestingly, the Federal Justice Department deprioritized enforcement of federal marijuana laws for states that had medical marijuana laws. Basically, there was a memorandum that came out of the Federal Justice Department which said all U.S. attorneys basically needed to make it one of the lowest priorities to enforce federal marijuana laws against medical marijuana issues in states that had medical marijuana laws. 2014, Congress passed what's known as the Rohrabacher-Farr Amendment. Congress defunded all DOJ activity in states that had medical marijuana laws, as long as the individual that the feds otherwise would be prosecuting or following state law, no more federal funding for the DOJ action. This has been affirmed by the courts. In 2015, USA versus Marin Alliance, there was a medical marijuana dispensary up in Oakland that for years had been fighting with the federal government. In 2015, the lawyers for the medical marijuana dispensary went to court, and the judge agreed with them. They had to dissolve the injunction, and the feds had to stand down because they had no money to enforce the injunction. Interesting case. 2015, California passed the Medical Marijuana Regulation and Safety Act. Now, this is important because we hear so much about Prop 215, and we hear so much about the Adult Use of Marijuana Act. Most of the regulations in Prop 215 for state licenses are a mirror of the medical marijuana licenses that are coming out in 2018. Both medical marijuana and recreational marijuana businesses will be regulated by a new Bureau of Marijuana Control. So both of these business operations, recreational and medical, will be regulated by the same state agencies. And so the medical marijuana regulations in 2015 are important to understand because the recent proposition that passed is largely mirrored on it. 2016, another court decision on the defunding of the federal prosecutorial authority against states with medical marijuana laws. Federal Ninth Circuit affirmed that you couldn't use federal money to prosecute medical marijuana operations in states where you're following the state law. 2016, a Gallup poll showed 60% of Americans support legalization of marijuana. 2016, why we're here today, California passed Prop 215, Adult Use of Marijuana Act. Also in 2016, the election of Donald Trump to the presidency has created some uncertainty on the federal stance towards enforcement of federal laws. And that brings us to now. Controlled Substances Act remains valid law throughout the country. That's the federal ban on all marijuana. However, 29 states in the District of Columbia have legalized medical marijuana. 8 states in the District of Columbia have legalized recreational marijuana use. And that's where we are now. And starting in 2018 in California, as I mentioned before, 2 sets of state laws, one passed by Prop 64, one passed by Sacramento, will allow for state licenses to be issued. And the city needs to be ready before those state licenses are issued on what local control they want to keep. So thank you all for listening to that hopefully short and sweet summary of marijuana laws. Now we're going to get to the meat of the matter. First issue, and as I mentioned before, there's 4 issues. We're talking about personal marijuana cultivation, personal marijuana use. We'll be talking about commercial businesses, and then taxation and fees. And I'll pause during each of these 4 topics so council can discuss, ask questions, and hopefully we can reach some sort of complete understanding of these different issues.
Any questions at this point? Okay. Thanks.
I'm struggling to understand the differentiation between Prop 64 and Prop 215. I thought we just recently passed Prop 64, but
Yes.
it's referred to here as Prop 215.
Yes, the council member brings up a good question. California voters passed the Compassionate Use Act back in 1996, which was for medical marijuana. And then Prop 64 was just passed, and that's for recreational marijuana.
What is Prop 215? The Adult Use of Marijuana Act.
That's a misprint, I think, on the paperwork.
Oh,
The last slide.
The recreational use is Prop 64, medical is 215.
Oh, yes, that's a typo. My
so the
mistake.
1996 was 215?
Yes.
Okay,
Yeah.
thank you.
Good catch. Well, thank you for paying so much attention to that's a great catch. On that topic, interestingly, the Prop 64 is over 50 pages of amendments and changes to state law. Prop 215 basically just decriminalized medical marijuana. Vastly different in what they did in terms of the details of the law. Any other questions before I get into this first topic? Okay, so the first issue, personal marijuana cultivation. Before the passage of Prop 64, personal cultivation of marijuana in California for recreational purposes was completely illegal. The personal cultivation of marijuana for medical purposes was generally lawful unless the city banned the activity. The law, according to the Morro Bay Municipal Code, both before and now, before the passage of Prop 64 and now, is that all marijuana cultivation by any person anywhere in the city is illegal. Now, the current law, after the passage of Prop 64, is that whether a city likes it or not, anyone throughout the state can cultivate 6 marijuana plants, and cities cannot prohibit that. What cities can do is prohibit outdoor cultivation of marijuana plants. Cities can't prohibit the indoor cultivation of 6 marijuana plants at a private residence. And so the issue that cities can address to preserve local control now is whether or not they want to ban outdoor and whether they want to regulate indoor marijuana cultivation. So that brings us to the city's regulatory options for this first issue of marijuana cultivation, personal. Status quo in Morro Bay right now. Outdoor recreational marijuana cultivation remains illegal. Indoor, state law preempts the ban on marijuana personal cultivation. So right now in Morro Bay, as with every other city in the state, individuals can grow 6 recreational marijuana plants. The question is does the city want to regulate that? So possible options for Morro Bay. Like I said, right now, outdoor cultivation remains illegal because the city has banned all cultivation, and so continues to remain illegal outdoors. The city could allow outdoor personal cultivation. They could put on regulations, for example, like the property owner approve of the cultivation, maybe less than 6 plants. Status quo is outdoor cultivation remains illegal. Indoor, the city could impose reasonable regulations. It's good to point out that Proposition 64 provides little to no guidance on what type of regulations are okay. In fact, Prop 64 just gives us 2 words. You can impose, quote, reasonable regulations, end quote. I'm pretty sure that this is something that's going to be going through the courts on what is or is not a reasonable regulation. What is clear is that the regulation can't be so stringent that you're basically really prohibiting the indoor cultivation. For example, if the city said that, only somebody who also has, for whatever reasons, an airplane, a pilot's license, they're the only people that can get an indoor permit. That just makes no sense. It would prevent most people from growing. That would be certainly unreasonable. If a city said you have to grow all your marijuana within a 1 square foot spot in the house, that would be unreasonable. But what is or is not going to be allowed by the courts remains to be seen. Some examples that some cities have already imposed and probably would be considered reasonable is to require a simple permit, fire department inspections, electrical use regulations. I have some examples now on what other cities are doing for personal marijuana cultivation regulations. In Pismo Beach, Grover Beach, and San Jose, a review indicates that indoor cultivation of up to 6 recreational plants remains unregulated. Paso Robles has passed an interesting indoor regulation. It requires a permit, and you could only grow in an accessory structure. I expect that will probably find its way to the courts, and we'll see what a judge says on whether or not that's reasonable or not, but that's what they have right now.
Chris, can I ask a question?
Yes.
And when you're talking right now, these examples, are you including both medical and recreational cultivation?
These examples are for, yes, it would include both recreational and medical, but medical is, if you will, a subset of recreational. So right now you can grow marijuana for any reason indoors. It doesn't have to be for medical.
So for personal cultivation, we really don't need to distinguish between medical or recreational. We need to think about that when we think about commercial cultivation.
Yeah.
But you could have six plants with reasonable regulation, regardless of whether you have a medical intent to use it or a recreational intent to use it.
For the personal use, okay.
Yes, actually, the city manager made a really good point. The businesses, we want to distinguish between medical and recreational.
Sure.
For the indoor growing that the state says you must allow up to 6 plants, it's for any purpose. So if they use it for if the grower uses it for medicine, that's fine. If they use it for recreational, that's fine too.
Okay.
A few other examples of indoor regulations. The city of Indian Wells in Riverside County, they have imposed an indoor regulation of you need to pay $141 per year for a permit, which presumably is to cover the costs of the home inspections that they're requiring, which are to confirm there's only 6 plants being grown, that there's adequate ventilation and cultivations in a designated locked area. San Jacinto, also in Riverside County, they allow indoor cultivation only if a resident has no recent felony drug convictions or pending code enforcement actions. Montebello, LA County, or indoor cultivation requires a permit, which is only issued to people that at a minimum can't owe city fees, and they also have water restrictions. So you can see there's lots of different examples of what cities are considering to be reasonable regulations. The point is that right now, all throughout the state, people can grow 6 plants indoors. And the question for the city is, does Morro Bay want to regulate growing indoor 6 marijuana plants in the city? Status quo is that it's already legal and it's unregulated. So this is one of the 4 topics for the city to consider. So I'd like to now open it up to, I guess, discussion on the one of the 4 issues.
Okay, looking for discussion. I'm looking towards Marlis if you want to, or just open mic at this point. The mics are open, so anybody wants to pipe in? Anybody? Marlis, Matt?
I do have, in terms of the, this personal indoor, in terms of 6 plants, and the word was residence, and I think this came up in another one of our discussions. Folks came up, when we talk residence, so for instance, a single home, an apartment complex, and the slippery slope of someone owning multi-apartments, et cetera, could that be, how could that fit into any sort of regulation? Could the city say one building could, I don't know how to do that.
The issue of how you decide, the 6 plants are limited to a private residence. So if it's, you have 6 units in an apartment building and each of them has a private resident in each of those 6, they each would be able to grow 6 plants, I believe. But if you had one person that had a large building and they claimed that there could be, but there aren't 9 other people living there, they can't grow more than their 6 plants. So to answer your question, I think that the city reasonably could require proof that whoever's growing the 6 plants, that is their personal residence. So people aren't setting up 5 different grow houses around the city for their own 30 plants.
Sure.
You could make that a requirement, I think. I mean, just off the top of my head, when people register to vote, you have to give some proof of a residence. And I think we could perhaps use some sort of equivalent, if we wanted to say that you have one personal residence. Wherever that is, you get your 6 plants. But if it happens to be in this city, then you do your 6 here. If it happens to be somewhere else, you do your 6 somewhere else.
Can a city require that the grower be the owner of the property? And secondarily, can a landlord prohibit a tenant from growing?
The law expressly talks about people that are in apartment units, mobile home units, or equivalent dwellings. So I think it'd be difficult to say that you have to own the property to be able to grow the 6 plants. I do think a city, though, however, could reasonably require a property owner's consent to growing the 6 plants. But there's a distinction there.
Mm-hmm.
And how about as far as reasonable living conditions? As an example, whether it's an efficiency apartment or a 1-bedroom apartment, and ensuring that during a permitting process that you have proper living conditions, that you're not substituting a grow for a living residence, a living residence, I guess, yeah. So, I mean, those types of things to make sure that we're not, a property or a apartment doesn't become a growing facility instead of housing, a housing unit, which is a concern for most in California.
I think that a reasonable regulation could probably take the form of that for example, kitchen facilities, bathroom facilities, sleeping facilities, the basic areas of a normal residence remain unencumbered by the cultivation. I think there could be some reasonable regulation along those lines. I've seen cities to date so far require, for example, a floor plan has to be submitted to the city to get a permit, and you show where the cultivation is going to occur. A court might find that to be unreasonable, depending on how detailed you make the applications to get a permit. But I do think that you could set up something that says wherever the cultivation's occurring, it's not going to take away the living functions of that residence.
Okay, thanks.
And likewise, I'm thinking of energy use as some of these indoor operations, I've heard it can be very energy intensive and water intensive. I guess if you wanted to either control that, in terms of, the larger global idea of climate change, and would that be part of could that reasonably be part of the permitting process too?
Yes.
Chris, does the regulation, law, I should say, require that the indoor cultivation be only utilized vis-a-vis smoked, eaten, whatever, within that building? Or is there anything in the law that specifically says where it can be consumed?
Proposition 64 provides that an individual can possess, use, transport up to 1 ounce, and that includes they can give away without compensation that 1 ounce to anybody else. That 1 ounce or 28.5 grams can be the result of what you've grown on your own. So the answer to your question is you can't limit the crop, if you will, or the harvest from the 6 plants to staying in that building.
But how about the personal use? In other words, I grow 6 plants in my home. I want to smoke it on my porch or on the way to work in my car. Is there anything that regulates that?
Oh, yeah. The Prop 64 makes it clear that you can't smoke in public places. You can't smoke while driving a motor vehicle. So if somebody grows their 6 plants and then decides to get behind the wheel and smoke while they're driving, that would be illegal.
That's a bad example. Let me just suggest, like on my porch, or in my neighbor's garden. If I've grown my 6 plants and I take less than 1 ounce with me, and I go to a party in my neighbor's house, and I smoke or eat my stuff there, is there any prohibition? Or I guess I'm asking, are there any limitations on growth and consumption?
I think there's no connection to what you're growing for personal use and where you use it. We're going to get into item 4 that talks about how you can or can't use marijuana legally outdoors if there's a ban on smoking or something like that, but there's no requirement at all that if you've grown it in your home, you can only do certain things with it. If you've grown it in your home, you can do anything legal with it anywhere. Is that?
So does the law allow for, let me say, would it be appropriate for a city to make interpretations about health and safety issues such as an asthmatic child living in the house with an individual and not allowing the consumption because of the health status of individuals, which may be adverse, et cetera?
That's an interesting question. I don't know if the city wanted to balance the health needs of an asthmatic child in a home against the now state enshrined, I guess, right to use marijuana, I suppose that you wouldn't even need a law to, if that was a problem, to come in and, I suppose you could call Child Protective Services. You could even find that there's some form of a nuisance activity occurring. If somebody was endangering the health of their child in that form you describe, I don't even think you need a law necessarily to stop that.
Okay, thank you.
And Chris, in these cities that have passed regulations, do you have any idea of how they are enforced? Who's responsible for enforcement? And is the purpose of the regulation or any fees attached to it to pay for that enforcement?
The cities that have passed the regulations, right now, I don't know how successful they've been in enforcement. I would suspect that in most cities that are requiring permits for indoor regulation, they're going to see far and few between people registering to get those permits. And I doubt that unless the police were called for some other reason into a home, anybody would even know realistically if somebody's growing indoors. There's been a lot of unregulated illegal growing that occurs in the state anyways to date. But in regards to the fees that are collected, unless the voters approve the fees as a tax, then whatever fee you charge needs to go into regulating or administering the local regulations for that actual property. So you wouldn't be able to charge fees higher than whatever the costs are of regulating that property. Does that answer the question?
Yes,
Or?
yes it does.
Okay.
Thank you.
So, Chris, if I can maybe sort of summarize this section and see if we're, not summarize, but what I'd like to get out of this is to make sure that we all understand what the council's options are. So outdoor cultivation is currently legal. If the council wanted to make it not legal, they would need to take action to do so.
Right now, Morro Bay prohibits cultivation across the board,
Yeah,
so outdoor cultivation, because of the existing law, is illegal in Morro Bay.
Yeah, under state law, though, outdoor cultivation is legal.
Correct. Yes.
And so we'll probably end up refining all of our ordinances in the area of marijuana as we go through this. And so you would either want to reiterate the existing Morro Bay code that says outdoor cultivation is banned, or expressly say outdoor cultivation is not banned.
So are you suggesting that state law does not preempt local government in the area of outdoor cultivation?
It doesn't in this case because the proposition allows you to ban it.
Okay.
State law does preempt us in other areas, such as personal indoor cultivation, because we're preempted.
One way
To be clear, though, so if we didn't have a law that banned outdoor cultivation, then currently it would be legal.
It would be legal.
So,
Yes, right.
So our questions are, do we want to, is that the position we want to maintain?
Right.
And
Exactly.
moving forward. And those might be issues on the short term that we might want to address sooner rather than later as we go through this process, because the process beyond some of the other ordinances and big scope of dispensaries and things like that is going to be a process that we'll discuss throughout the year before we, okay, thanks.
And then on the indoor side, indoor cultivation is for personal use is legal. We can't change that. You know, the state said that. You could choose some reasonable regulations, and I would recommend at the same time, if you consider that, then we should also consider the cost to enforce those regulations and assess a fee in order to do that enforcement. Otherwise, you're giving your city staff essentially an unfunded mandate, and we're going to burn code enforcement time or police time on things. And so those are the two things. Choose if we want to keep our outdoor ban or allow outdoor. And then on indoor, choose if you want to have any reasonable regulations, and then whether you want to associate a fee with that for the enforcement cost.
Okay. Yeah.
Okay. The second issue of the four that we'll be discussing today is personal marijuana use. This topic is not going to be covering a whole lot of ground for the simple reason that Prop 64 has now legalized personal marijuana use throughout the state. The Adult Use of Marijuana Act says that it's legal to use, possess, transport, and to give away without compensation up to an ounce of marijuana. Now, before Prop 64, personal use of recreational marijuana for non-medical reasons was completely illegal. And as I just mentioned, now it is legal. However, there's three different items that I wanted to focus on that the city still has some local control over in regards to personal use and regulation of it. One is a city employee policy. The city actually has recently updated its drug-free workplace policy, which will be on a council agenda coming up soon for approval. So the city's ahead of the curve on that. Two, the city can actually, if it wants to, take a look at whatever rules or regulations it has for city property when it's leased to somebody else and whether or not they're going to allow marijuana use. That's an option. The city doesn't have to do anything there, but it's an option. And the big area, and again, Morro Bay is ahead of the curve here, is that if cities want to regulate personal use of marijuana outside of one's home, then it's been recommended that the best way to do that is just to ban cigarette smoking, ban smoking in general more extensively in a city. However, Morro Bay already has a very comprehensive anti-smoking ordinance. So Prop 64 is clear that anywhere that you can't smoke tobacco, you can't smoke marijuana. And because Morro Bay's anti-smoking ordinance is so broad already, the city's already basically got in place one of the, I guess, one of the strongest options available for local control of use of marijuana.
I have a question.
Yes.
On this city employee policy, that it simply applies when they are at work on duty, correct?
The new policy that the city's adopting, yeah, I believe that it applies to when individuals are at work. Or on call, yeah. The actual details of the policy, I would need to take a look at it to summarize for you exactly the ins and outs of, I guess, use outside of work.
I think there's also something about a 12-hour period before doing a job that requires operating a vehicle. But let me ask you a question about this, the smoking. Morro Bay has a no smoking ordinance, but it does not enforce that ordinance. So if in the future we chose to enforce the ordinance for marijuana while we are not enforcing the tobacco ordinance, where are we with that? That seems selective to me.
I would suggest that it be equally enforced.
Mm-hmm. Okay, so if we want to truly prohibit outdoors or public smoking of marijuana, we need to begin enforcing all smoking.
If the city were to use the general no smoking in certain area law, the city also can, if there was the problem with, say, odor, or if there was a specific heavy concentration of use, the city could bring some sort of nuisance action against repeated smoking. But if you're talking about just casually somebody walking down the street smoking, say, a Marlboro as opposed to, say, a marijuana cigarette, then, yeah, I would think that you'd probably want to be enforcing the current law against both of them.
Okay.
Chris, there's no link between smoking and, for instance, transdermal use or eating the marijuana. For instance, if we ban, if there was an ordinance that banned the smoking publicly of marijuana, that would not automatically mean that it bans transdermal use or possibly oral use, et cetera, correct?
That is true.
Okay, thank you.
Okay, so there wasn't a whole lot on personal use to go over, but if there's any discussion, further discussion on that, or else I can move on to the third topic.
Keep going.
Okay. The next topic is marijuana commercial operations, and this one is has a lot of ground to cover. And what I will first talk about is the law before Proposition 64. Before Prop 64 was passed by the California voters, recreational marijuana commercial operations were completely illegal in California. Medical marijuana commercial operations technically were illegal. They were supposed to be nonprofits, cooperatives and collectives. But medical marijuana dispensaries, medical marijuana cultivation has been legal in the state since 1996. In cities, the courts have been clear, can prohibit or regulate those medical marijuana operations. Before Prop 64, the Morro Bay Municipal Code prohibited medical marijuana dispensaries, prohibited all marijuana cultivation with a small exception for personal medical marijuana cultivation, and it prohibits the issuance of licenses basically for marijuana manufacturing. So that was before Proposition 64. Now, the current law, since Prop 64 passed, recreational marijuana. As I'd mentioned before, by January 1st, 2018, the state of California will begin issuing 19 different types of recreational marijuana commercial operation licenses. When I say 19, there's basically 5 different categories. There's cultivation businesses, there's retail businesses, there's delivery, there's manufacturing, and there's testing. The biggest group will be the cultivation licenses. There's 13 different cultivation licenses because they're pretty specific about the size of the area that you can cultivate in, whether it's indoor, whether it's outdoor, whether it's mixed light, whether it's a nursery. So there's lots of different cultivation licenses. As I mentioned before, the state of California passed a medical marijuana regulatory overhaul recently, which Prop 64 largely mirrored. And so in January 1st, 2018, the state will also start issuing medical marijuana commercial operation licenses. And there'll be 17 different types for those. When I said there's 19 recreational commercial licenses and there's 17 medical commercial licenses, they didn't have the exact same types that will be issued, but suffice to say, there will be a whole different regime in 2018 when the state starts issuing these. The key here for city action is Prop 64 was written by marijuana advocates, and medical marijuana rehaul that was done was written in Sacramento, which means that there's a big difference between getting a state license for recreational businesses and medical marijuana businesses. If the city doesn't take affirmative action by ordinance to address the recreational businesses before state licenses start being issued, there's a decent argument that the state license allows you to operate in a city if you don't ban them. The courts are going to have to figure that out. But Prop 64 arguably says that unless you ban an activity a state license will allow, the state license lets you operate in that city. Medical marijuana, it's a different story. A medical marijuana license only entitles you to operate a commercial business in a city if you also have a city license. So what I'm emphasizing here is the city really needs to address what it wants to do with these recreational marijuana businesses before the state licenses start coming out. Hopefully that wasn't too confusing, but we have 2 huge sets of state laws here, and they're kind of similar, they're kind of not. The Morro Bay Municipal Code, what does it say right now after Prop 64 passed? There's a current ban on medical marijuana commercial dispensaries. The Morro Bay Municipal Code is silent on recreational or non-medical marijuana commercial dispensaries, which means that arguably if the city does not prohibit them, then once state licenses start being issued, that would probably lawfully entitle someone to operate in the city. I won't say for sure because that would be for a court to determine. The new law is a little unclear, but the city likely should deal with that before the state licenses start being issued. There's a current marijuana cultivation ban, which probably would act to prohibit all commercial marijuana cultivation. The current code is silent on delivery and testing, and the current code arguably prohibits manufacturing operations. Echoing what the city manager had mentioned earlier in this presentation, I would suggest that the city probably will do an overhaul of its entire marijuana code. The current code was for a prior era, and it'd be better to just address these new laws in whole rather than trying to argue that maybe or maybe not it applies to some of these new businesses.
Chris, what does the area of testing entail? When I think of testing a product, I usually think of a regulatory agency testing for various components and then certifying to the consumer. Is that what this model is as well?
Yes, in most respects. My understanding is the testing will be for two things. One, it'll be for contaminants like, say, pesticides, to make sure that the product's free of contaminants or toxins. The other will be testing to make sure that whatever compounds is being advertised as being part of the product, basically how, I guess, high it gets you. Or whether it's going to help like with a certain type of medical ailment, testing to make sure that that's accurate. So there'll be two types of testing. Contaminants, make sure they don't have it, and then also just to verify that whatever it's being advertised as doing is accurate.
So it will be qualitative and quantitative?
Yes.
With regard to that, is that what you're saying?
That makes sense.
Okay.
I like that, yeah.
So we're talking then about establishing a city department of testing and licensing?
No, actually, the state will have standards for the testing, and the city, if it wants to, can allow the testing facilities which conduct the testing to operate in the city.
Okay.
Yeah, there has to be testing done before the cultivators can provide the product to the retailers under the new system.
Okay, thank you.
In fact,
City testing will only take place by employees after hours.
And that's 12 hours off. Like it does now with administrative staff.
Chris, I do have a question. In terms of setting this up, looking at the state laws, the 17 areas and 19 areas for the respective areas, within this time frame, if we were going to go by line kind of, process of breaking it down, you would consider such things as the obvious of recreational and or medicinal, if you're going to allow those. Would that include also areas? Would you make a area like a business district? Would you make, and that's what you come up with all those subsets of laws to regulate that?
absolutely. In fact, if and when the city were to allow, say, medical marijuana dispensaries, then the question would be what zones, how many, do they have to be X amount of feet away from schools and parks? So yes, it would be treating it like any other business and deciding where they can locate, how many can locate, the permitting process involved.
So is this something that we want to incorporate into our general plan update? Or, well, actually, we have to decide first what we want to do.
If you're going to talk about the different areas, we have Measure D, right? You
Yeah.
can make Measure M. And if you
Is that M for Matt?
yes.
So one more quick question, as far as the testing goes, to kind of get clarified on what that would look like. So a testing facility would be, the product would come to them, they would be certified testers, and then once it was certified, then it would be transported out to wherever the customer is.
Yes.
Okay, so it's clearly a lab. It could be more like a lab clearinghouse type thing.
Yes. In fact, I know some cities are exploring allowing just, say, manufacturing and testing in their cities. So, they wouldn't have the cannabis grown in the city. It wouldn't be sold in the city. They would just have like a business park where there's some testing and manufacturing done.
Okay, thanks.
And can I?
And the I'm sorry.
Well, no, I was just going to, this is a prior question, really. I'm just wondering when this current Morro Bay Municipal Code took effect, because I know at one time we had dispensaries here in Morro Bay.
The current code right now, Chapter 9.06, that was passed recently to update the current code. I don't believe dispensaries have ever been legal in Morro Bay.
Yeah, Charles Lynch was arrested
He
in
had one?
2007.
Okay, but were they used to be legal then, and then okay.
Yeah, it was a combined sheriff and federal operation.
Yes.
Okay. So there used to be one, and then they busted it.
Yeah.
Okay.
What is manufacturing? What do you manufacture? Is it I forget. What do you manufacture?
Manufacturing is to create edibles like cookies, brownies, oils, creams. I know that there's some folks who use like cannabis creams for like joint aches. So it's the manufacture of creams. There's pills. And there's essentially two types of manufacturing licenses. There's one for non-volatile compounds and solvents, and one for volatile. And so the question is if you're going to allow manufacturing, there's two different types you can have in the city. And then also there's the medical manufacturing and then recreational manufacturing.
Chris, you'd previously used the word processing. Are you using those interchangeably, essentially?
Yes.
So whether it says processing or so cultivation is growing, processing or manufacturing is doing something with that raw product to turn it into something else. Testing is taking that raw product, checking it out before it goes out to be used for sale or something, and then there's sales.
Or manufactured into something. Right, okay.
Yeah.
Yeah.
Yes, exactly.
Yeah, I probably should have said testing second. So
Yeah.
cultivation is making the raw product. Testing is testing that raw product to make sure it meets standards. Manufacturing or processing used interchangeably here is turning it into something else, cookies or cream or whatever, and then sales is sales.
But that manufactured product could also be tested, could it not?
Correct.
Yes.
Yeah.
Chris, are there any of the regulations that apply to the paraphernalia that are utilized when consuming marijuana? For instance, there are industries now that make containers that they're sold in and various, smoking utensils, etc. Do the regs cover those kinds of manufacturer products?
I don't believe that Proposition 64 added any new significant regulations on paraphernalia. The existing, I guess, health and safety regulations that would apply already would continue to apply.
Thank you.
So we were talking about the commercial operations, and we were talking about in general, I was giving an overview of some of the city regulatory options on this third area, the commercial businesses. And as I mentioned before, and I wanted to emphasize again, on or about January 1st, 2018, and the reason why I'm using those kind of hedge words is that both the medical marijuana and the recreational marijuana laws say that by January 1st, 2018, these state licenses should be issued. It's already looking doubtful whether the state's even going to have the licenses ready to roll out by January 1st, 2018. Most of the information I reviewed recently indicates that they're going to roll out a few licenses to people that have already qualified under some sort of existing city or county regime. And just general licenses, who knows when they're going to be issued, because the state right now is working on the standards. But the point is that by January 1st, 2018, cities should be ready to know which businesses they want to allow or not allow. And you can ban them all, you can allow them all in, you can allow some in, you can regulate some. It's up to the city what they want to do. Some examples. Grover Beach has recently established a 70-acre, what they're calling a marijuana district. It's an overlay industrial zone for medical and recreational marijuana dispensaries, nurseries, manufacturing, and testing. And so what they've done is they've taken an area of the city where they've decided to concentrate these different commercial marijuana uses, and it's going to be a marijuana district. And as I'll get to later, the Grover Beach voters also approved a tax which will presumably be generating, according to Grover Beach, $1 to $2 million in revenue each year once the 70-acre site's up and running. I do want to emphasize that when we look at the tax revenues that other cities generate from marijuana businesses, Morro Bay has its own unique factors. So how much would be generated if Morro Bay had taxes, you can't just, sometimes it's apples and oranges. So I don't want to make it seem like what Grover Beach generates would necessarily be from Morro Bay. As opposed to Grover Beach, yes?
Yeah, I believe Grover Beach rescinded that ordinance before the second reading. But part of what led up to that raised a question in my mind having to do with cash transactions. If a marijuana dealer comes into a legal environment, purchases a piece of property for cash, $50,000 cash, can the seller take that cash and safely deposit it into the seller's bank account without being subject to federal seizure?
Probably, but I can't say for sure.
Okay. And I guess the question is, if the city gets involved with marijuana transactions and receives payment in cash for fees or taxes, and the city deposits the money into its bank account, is it considered by the federal government or the bank to be drug money that's subject to seizure?
You bring up a really good point, which is the intersection of federal and state law, which has been, if you will, bedeviling states and cities ever since 1996 when California rolled out the first medical marijuana decriminalization. As it stands right now, yes, technically the federal government could, I think, go into the 29 states and the District of Columbia and start seizing assets, technically. As I had mentioned, though, the Congress has defunded the ability of the Department of Justice to go after medical marijuana operations in states that have medical marijuana laws. And there's also the federal Cole amendment, the Cole memo that said that the U.S. attorneys are not supposed to prosecute in states with medical marijuana laws. They're supposed to be considered a low priority, as I mentioned in the overview. However, I want to be clear, the Controlled Substances Act is still valid law. And it still is on the books. And right now it's uncertain with the Trump administration and Jeff Sessions just being sworn in as Attorney General, what's going to happen on the federal level. So technically, yes, the federal government could enforce its laws in the way you described and the 29 states and District of Columbia. I've advised clients for years now that if they were going to develop a local regulatory scheme or ordinance to permit or allow medical marijuana dispensaries or just now recreational dispensaries, just keep an eye on what the federal government's doing. If the federal government suddenly changes its stance, then you could have, even in a local ordinance, some sort of fail-safe where if the federal stance changes, then that law is no longer going to be valid. I know that's something some cities have been looking into. But bottom line, that is valid federal law. The Controlled Substances Act is still the law of the nation. Okay, so other cities in the area, Carmel and Pismo Beach, they proposed a ban on all commercial recreational marijuana operations.
I'm sorry, Chris, but by not explicitly saying medical operations, but by being silent on it, then they're also saying they would allow it.
For medical, you mean? For
those two municipalities, they're saying to explicitly no to recreational, but by not saying.
Oh, yeah.
Okay.
Yeah, yes, exactly. Okay. That's the difference between the two.
Got it.
Exactly. So for city regulatory options when it comes to dispensaries or retail sales for marijuana, there are a couple of different issues to look at. One would be types of dispensaries. And currently the status quo in Morro Bay is medical marijuana dispensaries are prohibited, and so the city could decide to allow them. Recreational, on the other hand, right now the city does not prohibit them. And so when the state starts issuing licenses in 2018, reasonably that state license will entitle you to operate in the city if they're not banned before then. In regards to number of dispensaries, there are quite a few approaches on if a city allows dispensaries, how to go about deciding the number. One is just market demand, just like any other business. You know, how many ever businesses can open up and people support, they stay in business. Or you can limit the number, and there's three common methods. Lottery, a selection process where there's some sort of interview or application that occurs, or a first come, first processed, and we allow, say, only 2 or 3. Two examples of this, the city of Palm Springs, one of the first cities in Southern California to allow dispensaries. They originally allowed 3 medical marijuana dispensaries a number of years ago, and then since then, every year or two, they keep allowing 1 more, and now they're up to 6. As opposed to other cities, they just allow the market to determine how many can open up, and they just have a permitting process. Another issue for dispensaries, if the city were to allow them, the locations, as discussed earlier, of course you could limit them to certain zones, and you also can have distance requirements from schools, parks, houses of worship, and other dispensaries. And furthermore, if the city were to develop an ordinance to allow dispensaries, whether it's recreational or medical, there likely would be a number of regulations you would throw in there on top of the state ones, including record-keeping requirements, security cameras, lighting, hours of operation, employee training, insurance, alarm systems, guards, odor control, indemnification of the city. I've drafted a number of these ordinances for cities, and you know, there's just a wide range of what you can put into them. It just depends on how strict the city wants to be in its regulatory apparatus.
How do you measure odor quantitatively?
Odor would be something that usually you can't. Usually, a neighbor should not be able to detect any smell. Is how you do odor control. And so, if there's going to be cultivation occurring indoors, or there's going to be sales, and you know there's product in a store, usually there's a ventilation system that's required to be installed, so the neighboring property doesn't smell anything, doesn't smell any of the marijuana.
Okay, so it would kind of be complaint driven?
Yes.
Okay.
I'm sorry, Chris, and with that, Red, you make me think of another question. Creating smoke rooms, people going to dispensaries, recreational use, and smoking on premises. And so the same sort of would be the odor control, and would that sort of action be allowed?
Yes, Prop 64 specifically allows cities to, by ordinance, set up smoking sites, if you will, in the city, as you describe. And also the city can completely regulate that as well to make sure it's entirely enclosed. I guess the equivalent would be like a cigar room. Mm-hmm. It'd be like that, where sure. You wouldn't expect the neighbor to the cigar room, if it's in a retail area, to have, you know, the smell of tobacco like constantly being mm-hmm. you know, blown about. I mean, yeah. It's not like I guess it was, you know, before tobacco was banned from yeah. from bars. So. Mm-hmm. Okay, so that was on dispensaries, city regulatory options. And before I get to deliveries, was there any just general discussion that the council wanted to have right now on retail sales / dispensaries?
Are we going to talk about taxation later?
Yes.
Okay.
That will be the fourth big topic.
Okay.
I'm going through the commercial operations right now, the different types. So I've talked about dispensaries, and then I'll talk about deliveries, and then I'll talk about cultivation, and then briefly testing and manufacturing. And then I'll shift to the last topic for today, which is taxation and fees.
Chris, for the medical aspect of the dispensaries, will the new regulations do away with the requirement for a practitioner's prescription, or will that remain?
That's a good question. The requirement to obtain medical marijuana will continue to, you'll continue to have to get a physician's recommendation to get medical marijuana. However, recreational marijuana is now legal. So the question is well, why bother? My best answer to that so far is that medical marijuana retail sales are not subject to sales tax statewide, but recreational will be. And so there's an incentive for people to be able to buy medical. Also, you can only buy up to an ounce of recreational at a time. For medical, you can buy as much as your doctor recommends. So people might want to get a medical card if they medical condition is requires them to purchase more than an ounce at one time. So when you say, do you still need to get a doctor's prescription? Yes, to get medical, which would exempt you from sales tax. So the next topic, deliveries. This is a very important area for local control. And that is because for both medical and recreational marijuana, if the city doesn't address deliveries by 2018, then reasonably lawful dispensaries operating outside of the city can deliver into the city. So the city needs to ban it, or else it probably is allowed. And I hate saying probably, maybe, might be, but that's just the nature of the way these laws are set up, and we haven't had court cases to resolve them yet. But it seems pretty clear with deliveries. If you're silent on it, deliveries will be allowed. So the city should be addressing it one way or the other. So local control. Cities can ban or regulate deliveries of marijuana, both medical and recreational, into the city from outside of the city. They can do the same thing if you allow dispensaries in the city, the deliveries from those dispensaries. Cities can't prohibit the use of the public streets by delivery services simply passing through Morro Bay. So if a delivery doesn't start or end in the city, you can't stop someone from using the public streets. Options to consider. Current local law does not expressly prohibit deliveries. So if the city does not want out-of-area marijuana operations delivering into the city, then the city by 2018 should ban deliveries. Now, that is because by 2018 you're going to have these new delivery licenses that the state starts issuing. Status quo in Morro Bay right now is that if you don't allow deliveries, then reasonably they're banned. But once these state licenses start coming out, you need to have an affirmative ban to prevent deliveries. And again,
or some sort of,
if you want to prevent deliveries.
Or some sort of controlled mechanism for regulates the type of deliveries you want to allow.
I was just going to ask.
Exactly.
What would be an example of a regulation?
One regulation could be that you would require the delivery services coming into the city to register with the city, so you know who's delivering into Morro Bay. Another requirement could be that you might have invoicing on how much is being delivered. You start to get into privacy issues if you get too deep into what's being delivered to who. But I would think that just requiring some sort of regulation on who's doing the deliveries, making sure that they, have a valid driver's license, make sure that they don't have a criminal record, or, have some sort of background check on the delivery operations.
Business license?
You could do that too, absolutely. You could have a business license.
Chris, our current code requires a business license for deliveries into the city. So that would effectively do that, right? We wouldn't necessarily need to add something, but a marijuana delivery business would, since a auto parts store has to have a business license to deliver here, so would they.
Yes. That presumably that would take, I guess, one of the lowest forms of regulation where, you just need to pull a business license, and I mean, it's largely ministerial. But yes, you're absolutely right that you would, I think, need to get a business license to do the deliveries. Okay, so that's the one slide on deliveries. If there's any further discussion on that, otherwise I'll move into cultivation. Okay, so we're still on the third topic of commercial operations, and like I said, there's 5 types of commercial operations. There's the retail sales, deliveries, cultivation, testing, and manufacturing. So we're on cultivation right now. So there'll be 10 different types of commercial medical marijuana cultivation licenses that the state will issue in about 2018. And there'll be 13 types of commercial recreational marijuana cultivation licenses. Sounds like a lot. It is. No doubt about that. The differences, though, is basically the size of the areas you can cultivate, whether it's indoor, whether it's outdoor, and then whether it's mixed light. So it's not as many as you would think once you break it up into those categories. So those are the licenses for cultivation. The city, under local control right now, currently prohibits all marijuana cultivation in all zones. So right now, the city is prohibiting cultivation. The city probably has an effective prohibition against the medical cultivation from occurring in the city. I would advise the city to decide whether or not it expressly wants to allow, prohibit, or regulate the recreational cultivation and not rely upon, if you will, the code written for a previous set of laws. Now, what can the city do? It can permit only commercial medical marijuana cultivation. It can allow also commercial recreational marijuana cultivation. It can allow some of these license types. It can allow all of them. If the city wants to allow cultivation, then we can have a future discussion on the different types of licenses, or the city might want to just prohibit it all. But that's something that a decision will need to be made on for cultivation licenses. If the city allows cultivation, it can obviously restrict it to certain zones. It can limit the number of cultivation sites. It can impose regulations. And one of the first questions is whether you're going to allow indoor and or outdoor. So that's cultivation.
Excuse me, Chris.
Yes.
Can I one more question?
Sure.
We keep referring to this limited exception for medical. So under our current, what is it currently? Cultivation for medical.
The current Morro Bay Code,
Yeah.
I'm sorry, I should have clarified that in the beginning because I do keep mentioning that.
Yeah.
The current code says that an individual or their caretaker can grow enough medicine for that one person.
Okay.
So under the current code, you cannot be growing marijuana in general for medical patients. Rather, you can personally grow it, or you can have your caretaker grow it for you. So if there's any more discussion on cultivation right now, or we can move on to manufacturing and testing. Okay. So this is the tail end of the commercial operations, and then we'll get to taxation and fees. And I think we're right about on schedule. It's 5:30 right now. So the other commercial operations that the state of California will start issuing licenses for in 2018 are manufacturing and testing. Well, we'd already briefly discussed manufacturing. What does it mean? It's the manufacturing of edibles, oils, creams, pills. The city can allow some of them, can ban all of them. Again, it's just entirely at the discretion of the city. There's 2 types of manufacturing licenses. Basically, one is more dangerous than the other. Use of non-volatile solvents or no solvents, or use of volatile solvents. A city can pick which zones it goes in. And these manufactured products are going to be subject already to certain state laws regarding content, labeling, packaging, et cetera. And then we'd also talked about testing. There will be testing facilities that are required to basically, as the city manager mentioned earlier, take the cultivated product before it can be sold and test it for contaminants and to make sure that whatever compounds they say are in it are actually in the product.
Is that random, or is that every crop that comes out?
I believe all of the product needs to go to a testing facility. I'm not certain whether all of it there will be tested or just randomly some of that will be tested. But I believe it all has to go through a process of testing. It's actually a really
Chris,
good.
I know we're going to talk taxes and fees in a minute, but manufacturing processing sounds like it's exclusively a service activity, i.e. not a tax-producing activity in any sense. Are you aware of any taxation scheme for processing or manufacturing or testing?
Yes, actually, one of the examples that we'll get to, City of Gonzales just passed a tax where they're going to put a 50% gross receipts tax on just manufacturing. So it appears that they're envisioning their city being a hub for just manufacturing.
That sounds like manufacturing and sales of that manufactured product.
Well,
to retail vendors, right?
yes, it would be. Yes, it would be the wholesale. The gross receipts tax would be on the wholesale, and then it would be sold retail outside of the city of Gonzales.
So
It looks
testing
like.
likely would not generate, you couldn't devise a tax scheme for testing, but likely for manufacturing if the sale of that manufactured product happened at that facility.
Bless you.
Yes.
Okay.
And I think you also could put some sort of tax on just the manufactured goods because they're going to have to leave the city at some point. I mean, you know, I don't think you would. It wouldn't have to just be on sales. I think you could actually tax the activity as well, but the voters would need to approve that. And so the other type of commercial operation, like I said, is testing. And as I mentioned before, there's two main things that these testing facilities will be doing. One is testing for contaminants like pesticides, and the other one is conformance to the label content of the compounds, which basically means that if somebody says that their particular strain of cannabis is going to work better for, say, glaucoma than, say, a bad back, or if somebody says that it has a certain amount of THC in it, then presumably testing can be done to confirm that as well. But this is going to have to be worked out by the state regulations that are being developed still, and we don't have them completely. So that is the third topic on commercial operations. I am ready to move on to taxation and fees, which is the last topic, unless the council wants to talk about this general broad category commercial operations right now. Okay. Which brings me to the fourth topic. We talked about personal marijuana cultivation. We talked about personal marijuana use. We talked about commercial operations. And now this is the last one, taxation and fees. So there's a new Proposition 64 marijuana taxes that will be imposed upon the retail sales that will occur starting in 2018. And one of them will be a statewide 15% excise tax on purchases of marijuana. There'll also be a statewide cultivation tax. The Legislative Analyst's Office estimates that about anywhere from a few $100 million to $1 billion will be generated both from this tax and from the various local taxes that will be imposed starting in 2018.
Will there be a differential or differentiation between medical tax and taxation for the medical marijuana and recreational?
For the excise tax, it will apply to both medical and recreational, but medical marijuana retail sales will be exempt from sales tax. And so This new tax, the excise tax, will be on all purchases of marijuana. However, medical marijuana dispensaries will not need to pay a sales tax starting in 2018. So there basically will be up to 3 taxes on the retail sale of marijuana. You'll have the normal sales tax, which won't apply to medical. You'll have this excise tax, and then you might have a local tax, and you might have a county tax. It depends.
And will local communities see any of that money?
The money that's generated from the excise tax, it's a really good question. There is supposed to be some of the money devoted to communities and grants to help with the health, safety, and welfare impacts of Prop 64. But it's only available to communities that don't ban cultivation and don't ban retail sales. Now, how much money will be available? That's a question that we don't know for sure, but after going through all the different numbers and all the money that has to go to certain programs and breaking down how much goes to each city, very, very roughly, your average city in California might get anywhere from $50,000 to $100,000 a year in grants from this new tax. But that's average, and it could be higher, it could be lower. So there is some money available, but not a whole lot.
We'll do some more work on that. I would not take that to the bank.
No. Yeah.
I would.
It's good to clarify that, too.
The state of California is not in the habit of sharing its taxes with cities. So what we could reasonably expect is 1%, one of the percentage points of the 7.5% sales tax, which
would only be for recreational.
Yeah, which of recreational sales. Yeah, that's correct. Unless the city adds a city tax.
On medical.
Yeah, the city manager brings up, I think, a good point about just the reality of how the money flows will occur.
And if there are money flows, I would struggle with the word flows. Drips would be more accurate. Probably it's going to be in the form of grants for specific purposes, not general fund solutions to broader fiscal issues.
Yes, in fact, specifically the money that's generated by the excise tax, off the top you have a few million that has to go to the University of California for research. You have a few million that goes to research for driving under the influence with cannabis. You have a significant amount that has to go to pay for the administration of the new laws. And then once you have taken all that money off the top, you have 3 different pots. You have 60% that goes to that does not go to grants. You have another 20% that does not go to grants, and then you finally have 20% left over, where 1/3 of that might go to cities. So, and that's the short summary of it. So I agree with the city manager. I wouldn't hold our breaths on how much money goes to the cities in the end.
Chris, given the fact that, I'm sorry, real quick, like medical is exempt from the excise tax and federal taxation, can the city impose any taxes on medical?
Yes, the city can impose taxes on medical. To be clear, the excise tax, the 15% excise tax will be on all purchases of marijuana, both medical and recreational. The existing sales tax, which can range anywhere from 7 to 10%, depending on your city and county, medical is exempt from that, but recreational is not. So on top of those 2 or 1 taxes, depending if it's medical or recreational, the city then can impose its own taxes. And that brings me right to city tax options. You need voter approval. What cities have been doing to tax basically the retail sale or transactions of marijuana is they impose a gross receipts tax. Without getting too detailed on the difference and the mechanics of it, Suffice to say that sales taxes, which are imposed at the point of sale, are heavily regulated by the state, versus gross receipts tax are where the city tells a business every month, every quarter, every year, you pay us a percentage of your gross receipts. Whether you charge the customer or not, that extra, that's up to you, but you're paying us basically a percentage of your gross receipts. That is easy for cities to impose if the voters agree with it. Sales tax, though, is heavily regulated by the Bradley-Burns Act, and it's very difficult, if almost impossible, to impose specific product sales taxes. But at the end of the day, it's the same amount of revenue to the city in terms of a percentage of whatever the retail transactions are. So city tax options. You need voter approval under Prop 218.
2/3 or majority?
It depends on the type of tax that you're imposing. If the city wants to impose a tax that goes into the general fund, where the money raised can be used for any and all city purposes, then you need 50% plus one. If the city wants to impose a special tax, which means that the money can only be used for certain things, you earmark it for, say, parks or law enforcement or fire department, then you need 2/3. So there's the gross receipts tax, which is common. A lot of cities are imposing anywhere from a 5 to 15% gross receipts tax. And then there's a cultivation tax, which generally is taking the form of X amount of dollars per square foot of cultivation. I'm going to get into some examples of what other cities are doing, but before I get into that, there's also the fee options. The city, without going to the voters, can recover licensing and regulatory costs. Right now, if to say regulate and to inspect and to make sure that a business is following all of the local codes, it costs the city, I don't know, $200 a year for the inspections. You can charge the business for that. That fee can be recouped. Likewise, you can recoup licensing and regulatory costs on any of the marijuana commercial operations. Another interesting idea, some cities are exploring development agreements where the city will have a large cannabis cultivation operation or manufacturing operation come into the city and pursue your standard development agreement, which under state law means that zoning codes are frozen. Some fees are paid to the city to keep zoning the way it is, and then a few years later you have the development occur. Some cities are anticipating raising fees that they otherwise wouldn't have through development agreements through large cannabis companies like I just talked about. Whether or not that's an option for Morro Bay, I don't know, but I'm just mentioning it as another fee option. So some examples. Palm Springs. Palm Springs is one of the first cities in Southern California to start taxing and allowing medical marijuana dispensaries. Population of 46,000 with 6 dispensaries in 2014-15, $1.14 million in revenue. Desert Hot Springs, tax rate of 10%, 3 dispensaries. Population of 28,000, revenue of 200,000. Santa Ana, tax rate up to 10% of gross receipts. 20 dispensaries, population 335,000, estimated revenue $1.5 million. And San Jose, tax rate at 10% on 16 dispensaries, population 1 million, estimated revenue $4.5 million. And I want to emphasize that even with putting in population numbers here, it's really hard to say because one city raises X amount of dollars that Morro Bay would raise that much. Obviously it's a factor of local demand, competition from neighboring cities, how much comes from the local residents purchasing versus people driving in. There's a lot of different factors. Some other examples, projections and local example. As I just mentioned, whether the city would realize the same revenues as people are estimating they'd get or have received depends on a lot of factors. That being said, King City in Monterey County, they just had a marijuana tax passed by the voters, population of 14,000. The city estimates that it'll raise $1 to $2 million annually. City of Gonzales, their proposed marijuana taxes, they project it'll be up to 1.6 million. The actual details, King City, they're proposing that there'll be a $30,000 annual fee just flat for testing and manufacturing facilities. The voters approved it. That's one way to do a tax. And then also they're doing a $25 per square foot cultivation tax. City of Gonzales, they're doing $25 per square foot for cultivation, and then a 50% on gross receipts of marijuana manufacturers. Now, Grover Beach.
Can I just comment on both Gonzales and King City? Obviously, agricultural communities with lots of space, and they are consciously working on some of these development agreements also because they have lots of space to do that, and it is a niche in the market that we might not be well positioned to appeal to just because of space. We don't have a lot of land that's available for that sort of large scale cultivation operation. Power plant.
Yeah, I definitely want to underscore what the city manager is pointing out, that every community has their own unique circumstances and attributes, and definitely these two cities in Monterey County, there are differences in why they might raise significantly more revenue than say Morro Bay would with the same types of operations being allowed. And then there's only one city that I could find so far in San Luis Obispo County that has voter-approved marijuana taxes, and that's Grover Beach. The voters did approve taxes at the last election in Grover Beach. 5% tax on gross receipts of medical marijuana businesses, 10% tax on the gross receipts of recreational marijuana businesses, and then a $25 per square foot on cultivation. They dropped it down to $10 per square foot after that. For what it's worth, some cities just do a flat $25, $20, $30 per square foot. Other cities, like Grover Beach, will, after you reach a certain amount of growth space, then lower it. But that's just a regulatory decision. And these taxes, of course, all have to be approved by the voters. So if Morro Bay was to do a tax like this, it would need to send it to the voters either at a special election or a general election. And there's, of course, various procedures to follow for that as well. Well, congratulations to all of us. We made it to the end. I wish.
So we want to open it for questions and more questions from council at this point. Dave?
If I could just sort of summarize, Chris, and help me here on the second area that we talked about, which is the various cultivation, delivery, storefronts, and those things. Not thinking about what our current policies are, current ordinances are, because I think what we'll likely end up doing is we might have some interim ordinances, but then somewhere towards the end of the year have a complete fresh chapter or part of the Morro Bay Municipal Code that rescinds everything else and says, like Chris said, that was the old days, here's a new situation. So we have really 4 decisions, I'd say, to make associated with each with medical and with commercial or recreational use. So medical storefronts, medical deliveries, medical cultivation, commercial cultivation, and medical commercial processing, manufacturing, testing. And then the same for recreational, so recreational or adult use storefronts, adult recreational delivery, recreational cultivation, and recreational processing, manufacturing, testing. Those are generally that's where the meat of the questions will be. And then we had 2 questions earlier on personal use cultivation, outdoor, whether to allow it or ban it, indoor, whether to regulate it. And then perhaps a few things to just review in personnel policies, policies for use on city property, and no smoking regulations.
So questions about the interim part of things. So kind of the discussion on what we might want to discuss for the short term, and some of the notes I have, whether our outdoor into indoor cultivation is something we would want to pursue. And then I guess the other question is, are there any other points of interest from others on council on what would be short-term interests? Those are two that I wrote down. And there again, if those are concern points on those in the short term, to have something like that, as Dave was saying, hey, we'd have an interim, and then at the end of the year, we'd kind of rescind that. We'd fine-tune everything we want to do. But those are some topics I think that's worthwhile discussing as well, and then thinking about how we'd go through that timeline of getting through some sort of interim policy or ordinance. So,
Chris, generally, licenses for recreational activities are not going to start be issued until the end of this year. True statement?
Yes.
Generally. So we don't have to take quick action on anything to do with commercial cultivation, storefronts, deliveries, anything. Our codes currently essentially prohibit any medical, the whole medical side of it. So we don't have to do anything quickly on that either. I think the one area that you may want to consider a sooner than later decision, is in the area of personal use, and specifically personal use outdoor cultivation. There is likely personal use indoor cultivation already happening, that's been happening, and we did. I don't think Chief Cox can confirm, but we don't spend a lot of time responding to or being concerned about the previously illegal and now legal indoor cultivation for personal use. Fair enough. One area you may want to consider is if you may want to consider, especially if you think this is the direction you might be heading, taking a position on outdoor cultivation sooner than later, because outdoor cultivation is legal right now, unless you do something to prevent it. And that's the one area where I think Chief might have some concerns about the community impact of outdoor cultivation, and I think that's really the only area, Chris, where some interim ordinance or action might be needed, and the rest of this can continue on with a longer conversation, and then have a comprehensive change to our municipal code in 4, 6, 8, 10 months.
Outdoor cultivation right now, the city might be able to impose more vigorous enforcement, I suppose, or have some sort of stricter penalties. But right now, technically, under the current code, outdoor cultivation is illegal. In fact, the current code bans all cultivation, and so it's just an operation of state law says you can't ban indoor. So states carved out indoor cultivation and allowed it. But right now, Morro Bay bans all cultivation, period. So, and then after Prop 64, indoors has been carved out. It's been preempted. But the city could allow outdoor if they want to. It could allow it under certain conditions if it wants to. And indoor right now, the city has to allow it, and it's unregulated. Yeah. Whether or not regulating indoor could even... How difficult it will be to enforce indoor regulations is anyone's question. I don't know. How many people are going to show up to City Hall to get an indoor permit if they've already been growing for a few years? Probably not many.
Any other questions or comments or input?
Just the comment that I think what you said, Dave, is true in terms of we do have until December, but it is March, and time flies, and we have a lot going on. So I wouldn't want to see it put on the back burner for 3 or 4 months. I'd want to make sure that
That was
we're
really the
moving.
next, thank you. That was, and it certainly wasn't indicating that we should take a pause. This is the second time in 2 weeks we've been discussing this, or in 4 weeks, and for a good reason. So this is the beginning of our robust community conversation on this subject. One of the things, this was, as I said at the beginning, mostly educational to make sure that we all understand the lay of the land. The one piece of guidance that would be helpful for the staff is where to from here. What does, based on what you've heard and what we know, what does a robust community conversation look like? How long does that happen for? What things might you want to provide direction to the staff on how to conduct that? And about how soon do you want to be wrapping that up and coming back to you for some presentation of what we learned, and then some guidance from the council on which direction you want to go on these 10 or 15 different decisions?
One thing I think we've seen in the last close to 19 years since the passage of the 1997 law here in town, we have a number of people here in town that are interested in probably both recreational and medical, but certainly the medical use and cultivation. And knowing that there's a lot of people here in town, at least me hearing it and talking over the last 20 years with people, in terms of what you bring up in terms of robust public discussion, and I know we've had a number of different workshops in different capacities, but I can definitely see having people come in, like we've done in our tables, have people come and list their ideas, put these ideas on table, and we can have a mobile walking around, letting people interact. Just because I know that there's a very valid energy in Morro Bay to analyze this issue. So I think opening it up for people to not just listen, but to participate.
Yeah. Well, and I'm also wondering, if we want to break it up piecemeal and take one thing at a time, or if we want to try to really address it in a more comprehensive way initially, just to get some feedback from the community on it. Because I don't know how many times we can expect the public to come to a workshop like that and continue to give input. So I realize it's a very complicated topic, but Chris, you've done a good job of kind of laying out what some of the options are, and I think if we could do that and get input then on those options, at least in the broad picture of, do we want to regulate and tax, or do we want to prohibit? At the big picture level.
So we could prepare quite a simple survey that listed each of these things, and it saw all the various areas that the city could consider taking action. We could put that out any number of places to give residents the opportunity to provide input that way. And then schedule a workshop, which would be not this sort of format, but a workshop that sort of like the Community Goals Forum, that would be a public meeting. Council could be there. We could have results of the survey out. This survey we could do for 6 weeks, and within 2 months be having a workshop. And at that point, you might be ready to have a discussion in a council meeting on, based on seeing the results of the survey, the community discussions that you're going to have every day with folks, the results of the workshop, be ready to have a council business item that starts to provide some guidance to the staff and says, hey, based on this, we sort of come back in 6 weeks and show us what it looks like if we generally do this and do this and do this and do this.
I think what Matt said is right on. I think the community forum, like we did with goals, is just a great process. There was a lot of good interaction. People were at various tables, subject matter related, and if we divided it up with, I think, some of the major subject matters first, that are very broad, like do you support medical and or recreational use? That's one table. Two, do you support, taxation, manufacturing, et cetera, one could have a pretty good, robust interaction in maybe 2 or 3 sessions, in addition to a survey, which could be done too. So I'd be open for that. I think that worked well.
I would be as well, and maybe that can, once you get that information, it kind of frame out the series of steps it would take to get to the final end product.
Yeah.
I know, Dave, you were talking about, hey, we can get to a business item. There's, on the other hand, there's, for some it's better, it's good to have a schedule too. So, we could just say, hey, this is what we've learned. Over the next 3 months, we're going to have a study session, the second meeting of every month, and so they'll know that we're going to have 3 study sessions on this topic to get through the product, to get through the process. And those are some different ideas I'm sure that we could probably formulate after we get that initial framework from the workshop as well. So,
Try to get a sense for some
survey.
Do a little bit of survey work before we get to the workshop.
I think that'd be great.
For some high-level decisions?
Yeah.
Yeah.
Yep.
And
Can we take a look at that survey before you do it?
And the PR aspect in terms of how we, we're going to do, I would like to look into or hear how we're going to use the PR aspect,
Bring that
Facebook,
up.
just the
Yeah.
internet, or just a website, somehow to use different mediums to reach different subsets. Phone.
Mr. Mayor, we may want to consider a council subcommittee on this, and then that way we could run, have the survey look, have them look at the survey and those things.
Yeah, that'd be great. Any further discussion on that or volunteers on a subcommittee? We've got one subcommittee, council subcommittee, so we've got two council subcommittee. Okay, so any other, okay, so we got 2 council members for the subcommittee?
It's good.
Yep. Okay.
That-
I know there's
think
volunteers. We're going to.
Should we have a, just, I think we can take council votes. You can direct that subcommittee. The council can formally form that subcommittee right now.
Yep.
Chris, can they do that?
Yep.
Wasn't noticed that way necessarily.
Yes.
Yeah, okay. So we have two volunteers for the council subcommittee, so Red and Marlis. I'm supportive of that, so we could just say, all in favor, say aye. Aye. Opposed?
Aye.
None. So we've got 5-0 support on our 2 council members for the subcommittee, council subcommittee. That's good. Yeah.
Now, I'll just say, I hope it's been obvious, but the city staff is not bringing and does not intend to bring at any time recommendations on anything on this subject. I'll rephrase that slightly. In the area of of some law enforcement issues, or if you develop a very strong regulatory framework that's going to cost the city a lot of money to implement, then we may recommend, like I sort of did earlier, that you also consider some permitting. But the staff, from our perspective, this is completely a political decision in a sense. It's not a business decision. We don't intend to write anything or put anything out any way that puts a finger on a scale one way or the other of anything.
Okay, perfect. Any further comments then?
Do you want to have public comment again?
Close for public comment?
Oh.
Any
Did you
public
want to
comment for the close of the meeting? Okay.
Okay.
Is the mic on?
Can't hear you.
Thanks, Bob.
Borrow that one there.
Good job, Bob.
Thank you. My name is Rick Morrison. I do operate MedMart Clinic at 334 East Olive in Fresno, California. There was a question that was asked that if people are going to be able to use marijuana recreationally, why bother to get the recommendation for the medical use of it? My first patient was in 1981. It was 15 years before the Compassionate Use Act. Is this not working very well? Sorry about that.
Better now.
How about I just lean down a little bit? It was my uncle. He developed cancer after smoking 40 cigarettes a day for 40 years, and he lost a lung and a half. And the first time the doctors recommended that he use marijuana, he fired the doctor, ordered him out of his hospital room. That's how opposed he was to this. 35 years worth of experience in using medical marijuana and talking to the patients and providing different advice and counseling. There's a substantial difference between medical and recreational. There are people that have survived cancer. There are people that have preserved their eyesight. There are people that have not wasted away and died because of what medical marijuana has done for them. And people that have taken the time and the if you want to call it heartache, to watch people that are suffering life-threatening and life-ending illnesses and being able to help them have some preserved life or quality of life is something that I've dedicated my life to. That's one of the reasons why I promote the medical aspect of it so much, and it's one of the reasons why I don't support the recreational. Technically, the only reason I don't support the recreational is because of my affiliation with my church. I don't think there's any harm in it. I did provide the videos that would indicate why marijuana has been illegal, and it is political. I would ask that you set aside any previous preconceptions or preconceived notions about marijuana as a stigma. I did provide the video in each of these handouts for each of the council members and the mayor, and it's 10 minutes and 41 seconds that changed my life. It was part of a tour that we did with the City of Fresno Police Department. And I made an agreement with Sergeant Wilson that if he didn't learn anything at this particular meeting, I would walk out of the city of Fresno and never turn back. And that was 5 years ago. So I believe in this as a medical therapy. I believe that this is something that would be a good fit for the city of Morro Bay. I thank you guys for taking the time and the effort to have these workshops and for inviting the people in the medical marijuana community to participate. Thank you very much.
Thank you, Rick.
I almost forgot. I did bring some marijuana products. Wasn't sure if I was going to be able. It's in a little sample case. It's a spice rack. If anybody's interested, I can show you personally the different types of products that they do dispense medically, why, how, and that type of stuff.
Thanks, Rick.
I just want to thank the council and staff for great questions, great discussion. I really appreciate the robust dialogue that you're having. And I would just like to add that Ethnobotanica really believes in paying its fair share. And I really appreciate that you've put priorities on particular issues of time-sensitive concern. It seems to me that revenue might be something else you want to consider as a priority to make sure that the city does begin getting revenues as quickly as possible, assuming that you do pass an ordinance. Thank you.
Thank you.
Powers with Megan's Organic Market. Just wanted to try to answer some of the questions that came up today. There's a question about testing and how that's done. Currently, how we submit testing, although we're not required to, we do submit samples of our flowers to a third-party lab where they are screened for toxins and pesticides. I grow the flowers myself. I'm aware there are no pesticides or toxins in my product. However, it's nice to be able to demonstrate to our patients that I'm telling the truth. Another thing I wanted to bring up, we really shouldn't have any concern about the 6 plant private cultivations becoming kind of a backdoor for commercial producers. This could have been possible maybe 20 years ago, but that's during Prohibition. That makes something like a commodity like that so expensive. So the price for this commodity just doesn't equate to that being a profitable venture for anyone. And it's almost to the point where it's not even profitable to grow it indoors using electricity anymore because California has such a great climate to do it in the free sunlight. And another thing too, for people who are needing to grow their own gardens indoors, the amount of electricity required for these projects typically is less than a space heater. Especially with 6 plants, it's not going to be worthwhile to set up more than about 1,000 watts of lighting for 6 plants. Also wanted to recommend that if we are looking at a process for choosing dispensaries or other businesses in the industry, I would recommend we do a selection process as opposed to first come, first serve or lottery. I imagine there's going to be a lot of interest in from outside the county, and people down in Southern California, Los Angeles, who maybe already have storefronts and dispensaries or looking to expand their brand. They might see something like this as a great opportunity to come in and kind of have the market cornered, especially if we're only going to allow, say, 3 of these storefronts in the area. So perhaps something we want to consider there. The other issue being we've asked for a business license from the city of Morro Bay before. We're told they don't issue business licenses for delivery services. Fair enough. That being said, it does sound like because we don't have a license, we should not be operating within the city limits. I suppose if the city came out and explicitly said that medical access is not allowable in the city limits, that's probably a headline that we're not wanting to see. Any questions for me? I didn't answer them, but that's all I have to say.
Thank you.
Thank you.
Thank you. Oh, don't do that, because I am a performer, too. Good afternoon. I'm sorry I wasn't here this afternoon earlier just to give you a little bit of briefing about ourselves. But our name of our company is called Elite Care California, and we were actually a very instrumental part. My name is Cynthia Gonzalez, and I live in Grover Beach. We were part of the, myself and my partner were 2 of the ones that actually initiated the Grover Beach ordinance, and actually our mission was to basically open up the entire Central Coast, because not only did we see the need from a medicinal standpoint for some of the patients that we have been working with for the past 4 years, but we also saw that there was a supportive endeavor where it would be a win-win situation. There wasn't any city that we found, even though it's such a high tourist city, that would not benefit from the tax dollars that could be supported by this medicine. The fact that there's so much of the business that's taking place here now, it was just made good common sense from a business perspective to be able to tax it and do it properly. Many of us have been working very closely with the Bureau of Medical Cannabis Regulatory. It's now called the BMCR. We changed that MRSA because we didn't like that association. So, and that being said, is that it's probably going to be one of the most heavy regulated businesses on the planet Earth. And there's a reason for that. For those of us that have been involved in the discipline of the business, seen cancer patients, seen the cachexia that they were discussing before, it is not a plant material, and it's not a medicine that works very well with synthetic drugs. So there's a whole learning curve. Many of us, we come from the research background. We work for corporate America. And our influence was working with actual oncologists, doctors. So we are not doctors ourselves, but we certainly have a good reference and a good supportive team that we work with in conjunction with doctors all across California. So I applaud you all on your effort to at least make this consideration for the Central Coast. It's a great need, and there are many people. The fastest growing number of patients, even here in our backyard, is the 65-plus market. The opiate factor that you read about that is a multi-billion-dollar corporation in the United States is not, it's not Aesop's fable. It is killing our elderly, and it's turning them into people that we don't recognize anymore. What we found with just a very moderate conservative dosing of medical marijuana, we can actually wean them from that type of Western medical drug, and still, if they were dealing with cancer, fibromyalgia, diverticulitis, glaucoma, we can still provide this as a complementary medicine that does not alter the Western medicine that is benefiting, but it's taking the pain factors away and giving them a substance that if they just drank a lot of water and cranberry juice, it would deplete out of their system within 3 to 4 days, if needed be. I bring these points up because those of us, like I said, that have been working with patients in the medical realm, it's been a very depressing market, I must say. Because for the most part, when we were working in the San Francisco and Marin County market, we were getting patients that were called the POOTs, patients out of time. Our goal and our function and finding that niche in the market was just to give them the ability to perhaps maybe live another 3 weeks, another 3 months. And we did that by providing them with tinctures. There was no pipes being smoked. There was no joints being rolled. It was tinctures, and it was suppositories, and it was topical ointments that helped get them through their worst and darkest moments as they were passing through life. So we've seen a lot of that. On the plus side, we've also seen patients that come to us with fibromyalgia. We've got amazing dosing. Now, we don't grow the plant. I come from a farming background from Kingsburg, California. Proud to say I was a raisin farmer for many years. I have a hospitality and a marketing background. However, we rely on the medical farmers that have been evangelists, so to speak, because not only do they understand this plant, but they know the importance of the various different strains and how it would be applicable to various different conditions. You brought up a point about the testing. Those of us that, again, have been in this space and working highly with the medicinal aspect, we have set the pendulum here. The industry right now says testing is not a requirement. Most people test because they want to know how strong is the strain. Can I operate a car in 3 hours after imbibing or ingesting? And then we have the most stringent questions, is that when we're working with a team of oncologists, we have to make sure that our plant material does not have any, not just molds and pesticides, not just the obvious, but metals that could be very detrimental to someone's physical health. Imagine introducing a metal or a foreign substance into a body of someone who's already dealing with a very chronic condition. So I wanted to stress the importance of the lab testing. It goes deeper than just what strain is specific to the condition. There was another issue that came up about deliveries, and although all of us want to be very transparent, most of us are business owners out of respect of this industry prior to even being involved, and for the most part, we understand the business model. We understand the importance of being, having legal support, having the proper scheduling, having the proper employment conditions for the people that work with us, and more important, having a transparent and open business so that if you, Chief, wanted to come and inspect our business tomorrow, our books are there, with the exception of the HIPAA laws. Because in the medical realm, even though we're not doctors and we don't have medical clinics, we still have to address the HIPAA factor. The other thing that came up tonight was and I wanted to share it with you, is there's a term called seed to tracking. This is going to be the state regulation. So in 2018, if anyone here, God forbid, had a debilitating disease, we would be able to go into a dispensary or contact a delivery and receive medicine that has been higher regulated than any food or any drug that any of us have ever taken in our entire life. It's going to go through an extremely scrutinization of safety measures. So that should give everyone a good sense of how this industry is being regulated. Another thing that came up in the presentation was the banking issue. Again, because of the federal background, we're prohibited from using banks today. It's a cash and carry business. Doesn't make a lot of us feel comfortable. But if you're working with a group of oncologists present and you've got a dying member of the family, children present, and you're dealing with medicine at that time, we don't have worries going to those environments. Where you have worries is going into some of the recreational / medicinal households. There are those of us that don't support that concept. I think that you'll find many people that are in this background that want to do right by this industry are certainly addressing that as a primary requirement. But there is today, I wanted to bring that up, there is today a lot of discussion about unions. Not unions, excuse me.
So ma'am.
Credit unions.
I appreciate
Credit unions.
all the information. We've got more information that will be going through this. Will you be available to come back at some of our other workshops?
We would like to, yeah, and
Good.
we certainly want to make ourselves available. Like I said, we were very instrumental with what took place with the L16 in Grover Beach, and we would love to have the opportunity to meet with any of you. I didn't mean to take the floor from anyone else that was here. You've all had a very long day, so thank you. I apologize, Mayor.
No, I do have to. I do try to be mindful of that, but I know that you're providing a lot of information, and I just want to be mindful too that as we
Yes.
go through this process, ensure that you are, helping with our community with
We'd be
some of the
happy to.
professional information that you have. So thank you.
Absolutely. Yes,
Can
sir.
you leave us
Thanks.
some contact information?
I will. I have a business card. I'm happy to share with you. It
Thank
says
you.
San Francisco number on there, but I have my 805 number on there too. So thank
Great.
you very much.
Thank you. And with that, we'll conclude public comment and end this meeting. I just wanted to say thanks for the presentation. It's a lot to go through, so great that you have the professional background on both sides, enforcement and kind of writing the lot. So that's been great. Thanks everybody for showing up, and for the viewers out there, there's a lot more processes and information to go through this. So we'll look forward to daylighting that a little bit more in some of the surveys. With that, unless there's any closing remarks, I'm looking towards council or anything. Then I'll adjourn the meeting. Thanks very much.
Thank you.
You're too young.